Dear friends, the Honorable Supreme Court of India has given a good judgment on the election petition filed by Sarita S. Nair against the Ernakulam MP Hibi Eden. This is a judgment given by three judges bench including the Chief Justice of India, CJI plus Bopanna and V. Ram Subramaniam. The three judges bench, while disposing the SLP number 10,678 by 2020 on 9/12/2020 in the case of Sarita S. Nair versus Hibi Eden held that execution of sentence or suspension of sentence is different from suspension of conviction. A person who got suspension of sentence cannot claim that he can be reinstated for the same post. So this was reiterated by the Supreme Court. Previously also in Lily Thomas versus Union of India and so many cases Supreme Court did the same. Right, as students you must know this. So the senior advocates definitely they know. Please remember, in CRPC, for example, the trial is completed. And once the trial is completed, maybe under section 235 CRPC, the accused will be decided so that he is convicted. Right? So conviction is one part. That means he has committed the offense or there is evidence against him to prove that he has committed the act. So he is convicted. Normally the sentences will be the accused is convicted and sentenced to undergo RI for 10 years like that. Even section 235 clause 2 says. So whenever you feel that accused is convicted, then you have to hear the accused on the quantum of sentence. That's why the court will present to him and the accused normally will say that he is aged man, he has got responsible family responsibilities, he is financially not sound and he has done so much of good work, social work in the previous time, so many things he will be telling. Of course, it is for the court whether to agree with the conditions or not. So here what you have to remember is, so convicted and sentenced to undergo. Similarly, section 33 CPC, it says, in a civil case, the court will give judgment and a decree. Judgment means, yes, this man, A is indebted to B. A has committed the offense of, say, A has committed the offense of non-payment of money to B. Is it not? So then how much amount? That is in the shape of decree. So convicted and sentenced. Now here, so the judgment and decree. These two sentences please don't forget. And here it is very simple issue. Of course, don't think that it is very simple. For making you to understand, I am giving these simple words. Definitely the case has got so many complications, but main focus is, the main thrust is on this only. Now let us go into the facts of the case. Mrs. Sarita S. Nair. So she filed her nomination in 2019 elections, which were held in the month of April-May 2019. So she filed her nomination for MP candidate in Ernakulam constituency on 4/4/2019. Right? She filed nomination in Waynard constituency also, and she filed another nomination in Amethi constituency also. Of course, on 6/4/2019, the returning officer rejected her nomination, stating that she was disqualified. Why? Because she was previously convicted twice in CC number 1300/13 on the file of in Pattanam Thitta case. So whenever you go to Ayyappa Swami temple, I think that is also located, Shabarimala is located in Pattanam Thitta district. She was convicted, where she was convicted to, sentenced to 3 years plus 5 lakhs fine in that Pattanam Thitta case in 2013. Later, in 2016, so she was convicted in another case in CC 102/2014 of Perambavoor. So where she was convicted by a sentence for 3 years and 45 lakhs fine. Of course, here what she has done is she approached the appellate court and got suspension of sentence orders. Please remember, suspension of sentence orders, that means according to section 389 CRPC, whenever you file suspension of sentence memo, normally it will be allowed, and here like that under section 389 CRPC, the suspension of the sentence was allowed, and she was allowed to file the appeal. But the problem is, in appeal also the appeal was dismissed. That means the conviction confirmed. But still, after the elections are over, of course she could not do anything as her nomination was rejected. Incidentally, her nomination was accepted in Amethi basing on the same facts, even though she stated that the two convictions are there, they have allowed. It's a different thing. Now let us confine to Ernakulam constituency area only. And now after the elections were over, then she filed election petition number 4/2019 before the Chief Election Commissioner. You may be knowing. So the High Court has got original jurisdiction in election petitions. So she has filed the election petition before the Honorable High Court of Kerala. Of course, they did not agree. First of all, here another point, they have found that her petition contained incurable defects, because she has not signed the verification statement as per Order 6 in pleadings. Under Order 6, Rule 15, you have to sign the verification statement that the annexures, all these things, the statements given by you are correct. Like that verification statement, she has not signed on it. And her request is also not proper. So last prayer, the prayer is also not proper. She has castigated unnecessary allegations against the Chief Minister of Kerala. Right. So basing on this, since they are having incurable defects, and that here what happened is the suspension of sentence is not suspension of conviction. Therefore, the writ petition the election petition was dismissed. Now she has filed an SLP before the Honorable Supreme Court. So this LP 10,678, it was also inquired into, and on 9/12/2020, Honorable Supreme Court also came to the same conclusion, stating that stay of conviction will be useful. Even in one case, Lok Parhari versus Election of Commission of India 2013, even stay of conviction by the appellate court is also definitely, it will not have any effect on the disqualification. Please remember, you may be knowing. So according to the Representation of People's Act, Section 8, Clause 3, what it says, disqualification on conviction. If any person is convicted for not less than 2 years, right, and definitely he can be disqualified for a continuous period of 6 years. So please remember, here she is convicted, but as far as the sentence, execution of the sentence is concerned, she was given a leverage to go out on bail and the sentence is suspended. But appeal also was dismissed, so her conviction is confirmed. So now she cannot say that since she is out on bail, or since her sentence was suspended, now she cannot contest her. Of course, she says that the election of Mr. Hibi Eden, her rival, is of course not and is not valid. She was not given a chance. Suppose she was given a chance, she should have won the elections like that. That was also not correct. Actually, she has to pray that the election of Hibi Eden is void, which she has not done. That's why High Court stated they are all incurable defects. Right here, the main point for concern is that please remember, stay of sentence is one part and stay of conviction is the other part. Just now in the beginning I told you, convicted and sentenced. Convicted is confirmed, but sentenced is maybe 4 years, or that sentence part is only suspended. So it is definitely disqualification in section 8 clause 3, and she cannot contest for 6 years from the date of that conviction, maybe some 2016 or so. So here another point, she has raised the point that when she filed a nomination in Amethi constituency, she was allowed, her nomination was accepted. But here Supreme Court said that merely the returning officer of Amethi committed an error. It cannot place the petitioner in the same position of doctrine of estoppel. Since he has done a mistake here also, so of course the action should be taken against him in that part. As far as this is concerned, definitely it is only suspension of sentence but not suspension of conviction. Or disqualification is 100% ratified. So the SLP is dismissed. Good case for discussion. Please remember, we have discussed so many points. Section 389 CRPC, Section 8 Clause 3 of the Representation of People's Act, Order 6, Rule 15 for the CPC students. So Section 235 regarding that connection also we discussed. Please remember all these sections so that tomorrow if anybody asks, you must be able to tell these sections from your lips. That is more important. That is what is wanted from the student. Right. Thank you.